Okay, so during our live session, we got a good start on Marbury versus Madison. The next time we meet, I want to talk more about Marbury versus Madison, but I wanted to put together a video to make sure that the rules are clear, right? Marbury versus Madison, the upshot is that the Supreme Court claimed for the federal judiciary, and when I say judiciary, this is really an important point. I don't mean just the Supreme Court, right? The judicial branch consists of, under Article 3, consists of both, right, the Supreme Court and inferior courts, right, assuming that Congress creates inferior courts, which it has, right? So we have, again, the Supreme Court, federal circuit courts, which is the Federal Court of Appeals, we have federal district courts, right? All of those judges of all of those courts, right, that's what we're talking about, not just the justices of the Supreme Court. Every federal judge has the power of judicial review, right? Because, and look at Marbury versus Madison, they say it is emphatically the duty and province of the judicial department. Everybody catch that? Look, I don't have the book in front of me, but make sure you find that sentence in Marbury versus Madison, right? The judicial department, it is emphatically, right, the duty and province of the judicial department to say what the law is. Okay, right there, and talk about game, set, match, right? That means federal courts, not just the Supreme Court, because judicial department means judicial branch, which means all of the courts, right? Federal courts have the power of judicial review. What is that? The power of judicial review is the power to resolve a case, right? It is the power to enter an order and a judgment, and if necessary, to strike down an act of Congress, right? To render invalid an executive order, right, issued by the president, or any policy or order issued by the president, or any state actor, any governmental actor at all for that matter, right? The power of judicial review is the power of a federal judge in the federal court system to issue an order which is binding, an order that is binding on the parties, and that, if necessary, can render any law, policy, or act of a governmental actor unconstitutional. Now, one of the things we want to keep our focus on throughout the term is, how does, let's be honest about it, right? You learn a new principle. One of the questions is, how in the world would that be tested? Like, what's the practical application of this, right? It seems like there would be no real fact pattern. I'm going to deal with this in the next video, but it seems like there'd be no real fact pattern that a professor could develop that would test you on the power of judicial review. As you'll see in the next video, there are ways, or at least a way, to test that. But one of the things that I want you to be aware of is the effect of a federal court judgment, and particularly one that doesn't have a stay on it, S-T-A-Y. Okay, in a constitutional case, you have somebody challenging the government, and you have the government, right? And sometimes the government loses, right? And that would mean that a court has found that something the government's doing is illegal, right, and for our purposes, unconstitutional. Now, if a court has found that, what's likely happened is that the court has issued some kind of injunctive relief, right? That's very common in constitutional cases, and ordered the government to halt a policy, or to implement the policy, to correct, right, whatever's going wrong. I mean, some kind of remedy has been issued. If you're the state or the federal government, right, if you're a lawyer for a local government, a state government, the federal government, and you've just lost in a constitutional case, that tends to be a pretty big deal. But any time that you lose a case and you intend to appeal, you can ask a court to issue what's called a stay, right? And oftentimes lawyers say stay pending appeal, right? That's a request to let's say the trial judge, in the federal system, a district judge, right? So you ask the district judge, okay, you ruled against me, I'm the government, you're enjoining like a statewide policy or a national policy, right? And I'm asking you to stay that decision because that's going to cause a real big logistical mess until an appellate court has had an opportunity to weigh in on this, because I plan to appeal. Most trial judges understand full well your right to appeal. Most trial judges don't have a problem with that, with you appealing their decision. And judges pretty liberally would grant, and in a big constitutional case anyway, pretty liberal, they don't always, right? But oftentimes will grant a stay, right? We'll issue the stay on their own judgment, right, to give you a chance to appeal. So now, what if a judge issues a judgment, an order? So this, again, goes with judicial review, the power of a court. If a federal judge issues an order, a final judgment in a case, and you ask for a stay, and the federal judge says, no, I'm not giving you a stay on this, right? You need to know that the effect of that, right, is that the judgment, it goes into effect immediately, right, and must be obeyed immediately. Otherwise, whatever government actor, right, was ordered to obey the judgment, right, would be subject to possible contempt of court, right, would have to show cause why they're not in contempt. Now, I want to talk briefly about another power, judicial something, but it's not judicial review. And this is a power, you want to pay attention to the Cooper versus Aaron case. This is a power that does not belong to all federal courts. This is a power that belongs only to the U.S. Supreme Court. And that is the power of judicial supremacy, right? The Supreme Court, unlike any other federal court, enjoys judicial supremacy. And what that means is well beyond, right, merely judicial review, because the power of judicial review is the power of a federal court, right, to decide whether a law or a policy is constitutional with regard to the facts before it. Now, that is not to be understated or underestimated. A district judge, you know, there's a lot to this, and some of it is civ pro type stuff. A district court judge binds the parties to the lawsuit, right? A circuit court, a federal court of appeals, a U.S. court of appeals, binds more than just the parties to the lawsuit. They bind all the lower courts in that circuit. The issue when we talk about judicial supremacy is who is bound by a Supreme Court decision, right, on a federal question. Now, before addressing that, I just mentioned the power of judicial review should not be understated or underestimated. So the power of a district judge, let's say I'm a district judge, I have the power to bind the parties, right? If I declare a law unconstitutional as to its application in this case, the two parties to the case are bound by my decision. Now riddle me this. Think about this. What if one of the parties to the lawsuit is the United States of America? Okay? Which is not unheard of, right? That is often the case, right? In a constitutional case, that one of the parties is the federal government, right? It's the United States. Now, let me repeat. If I'm a district judge, the parties before me are bound by my decision. If one of the parties happens to be the United States of America, then who's bound by the decision of one federal judge? It's the entire federal bureaucracy, right? The entire federal government, the United States itself, is bound by that decision. So, can one federal judge shut down right, an entire national program? The answer is yes. You'll see an example of that, right? Either in another video or live during one of our live sessions. But yes, one federal judge can do that if the United States is a party, and if there's some reason to issue a nationwide right, remedy or injunction. So the power of judicial review is quite a lot, but judicial supremacy goes well beyond that. Judicial supremacy, which again is enjoyed only by the Supreme Court, is the power of the Supreme Court when it issues a final opinion and judgment, right, on a federal question. Not just to bind all lower courts, not just to bind the parties, right, and not just to bind all lower courts, right, in the United States on the federal question. But check this out, right? But to bind, the power of the Supreme Court to bind, right, every state actor in the United States, okay? Not just courts and not just the parties. Every state actor, because remember in a constitutional case it's the government, right, that's being challenged, right? Every state actor, federal, state, and local, every single one of them, down to dog catcher, right, is bound by a U.S. Supreme Court decision on a federal question. So when you look at Cooper versus Aaron, right, what happened, school districts in Arkansas said we're not going to go along with Brown versus Board of Education because we weren't parties. Okay, so again, I'm going to do another video on issue spotting here on this, but that's the argument. We weren't a party to Brown versus Board of Education. Check this out, right? So we're not bound by it. The only people who are bound by the Supreme Court's decision in Brown versus Board are the school districts that were actually parties to the lawsuit and had a chance to argue right on their own behalf and in their own defense. And I hope you noticed in Cooper versus Aaron, a unanimous court in which every single justice, right, personally signed the opinion, said to those school districts in Arkansas, get your act together and get it together fast. You don't seem to understand the power of the Supreme Court. There is no higher authority on a federal question. There is nowhere else to go. And once we have answered the question, right, once we have decided a federal question, there is not a single state actor in the United States, well, again, whether it's a governor, a county executive, a mayor of a city, a police chief, a police officer, right, a county clerk, or dog catcher, right, who is free to disregard a U.S. Supreme Court decision on a federal question. And that obviously includes public school districts and superintendents and principals and all of that. So all federal courts, right, have the power of judicial review. Don't be tricked on that, because people will fall for it. People will fall for the answer that says only the Supreme Court has the power of judicial review. Wrong. Only the Supreme Court has judicial supremacy. All federal courts have the power of judicial review, right? And the power of judicial review is the power to decide a case, to issue a judgment, right, to have an order obeyed, and to have it obeyed immediately if there's no stay on it, right? That means that that whoever's on the wrong end of a court judgment there, right, has no discretion, right, about whether to obey the court's order, right? The judicial review includes the power to strike down an act of Congress or the president or a state or subdivision of a state, right, and bind at least the parties, right, to the lawsuit. The power of judicial supremacy is the power of the Supreme Court to bind every lower court, and beyond that, every state actor in the United States on any federal question. One example of this, and we'll call it quits on this video. Some of you will have heard of Kim Davis, the county clerk. This is in more recent times than Cooper versus Aaron. After the Supreme Court and the Obergefell case, which we will discuss in Common Law 2, after the Supreme Court in that case decided same-sex couples had to be allowed to marry, right? A state is not allowed to deny a license to a same-sex couple. A Kentucky county clerk named Kim Davis decided she was not going to do that. She was not going to issue the licenses based on her own personal views. Then plaintiffs took her to court, right? A federal judge issued a show cause order, right? Ordering Kim Davis to show up in court and show cause why she should not be held in contempt. Listen to her argument. Her argument was, I wasn't a part of that lawsuit, so I don't have to follow, right, the Supreme Court's decision. From her jail cell, she found out that, in fact, the Supreme Court has the power of judicial supremacy, right? Eventually that was resolved in other ways and she was released, but she actually was put in jail for contempt of court because she, and more grievously, whoever was representing her lawyers, right, apparently had not read Cooper versus Aaron and did not understand the power of judicial supremacy, right, that is enjoyed by the Supreme Court. So there's a recent example of that. All right, those are the rules about judicial review and judicial supremacy. Another video coming on how those can be tested. Another video or two, I can't remember. I'll look them up and post them. Then again, I'll be posting more material in the days to come. But we'll talk more about the actual Marbury case in our next live session. So until the next video, stay safe and stay tuned.